Hey guys, welcome back to Fintelliq. If you've ever wondered what actually happens to your money, your house, or your bank accounts after you're gone, this video is for you. Because here's the truth, almost everyone thinks, I'll just write a will and I'm done. But in the US, a will alone can trap your family in something called probate court, and that can eat up your money, your time, and your privacy. So today, we are breaking down the real difference between a will and a trust. No boring legal jargon, just simple, clear explanations, real numbers, and a step-by-step blueprint you can actually use. By the end of this video, you'll know exactly which one protects your family better and why. The wealthy almost never rely on a will alone. Let's get into it. Let's start with the big picture. When someone passes away in the US, their estate, meaning everything they own, has to go through one of two paths. Path 1, the public probate court system. Path 2, a private trust structure. Now, quickly, here are your three main players. First, the last will and testament. This is the classic legal document most people already have or think they need. It decides who gets what, but only after you pass away, and it forces everything through probate court. Second, the Revocable Living Trust, or RLT. This is a private setup that avoids probate completely, and even helps if you become incapacitated, not just after death. And third, the Irrevocable Trust. This is the serious wealth protection tool. It actually removes assets from your taxable estate, which is huge for high net worth families trying to reduce estate taxes. Keep these three in your head, because we are going to compare them side by side in the next few minutes. Okay, let's talk numbers, because this is where it gets real. First number, 3 to 8%. That's how much of your gross estate value can get eaten up by probate fees. So if you have a $2 million estate, that could be up to $160,000 gone just in fees. Second number, 9 to 24 months. That is how long the average probate process takes in the US. Almost 2 years where your family might not be able to access money, sell property, or move forward. And third, 100% private. That's what a trust gives you compared to a will, which becomes public record. We'll explain exactly why that matters in a bit. So remember these three numbers, 3 to 8%, 9 to 24 months, and 100% privacy, because everything else in this video explains why those numbers happen and how to avoid them. Now let's put all three side by side in one simple table, so you can see exactly where each one wins and loses. Effective date, a will only kicks in after you die. A Revocable Living Trust and an Irrevocable Trust both work immediately, as soon as they're set up and funded. Probate avoidance, a will does not avoid probate, period. Both types of trusts do. Public privacy, with a will, your estate becomes a public record anyone can look up. With a trust, it's a completely private contract. Incapacity management, this one's huge and most people forget it. If you become incapacitated, say, in a coma or with dementia, a will does nothing. Your family has to go to court for a conservatorship. But with a trust, your successor trustee just steps in and manages things immediately. Asset protection from creditors, a will offers none. A revocable trust offers none either, while you're alive. But an irrevocable trust actually shields your assets, because legally, they're no longer yours. And finally, estate tax mitigation. Only the irrevocable trust helps reduce your taxable estate. So already you can see, a will is the bare minimum. A trust does far more work for your family. So what actually is probate, in plain English? It's the court process where a judge validates your will, appraises everything you owned, pays off any debts or creditors, and only then distributes what's left to your family. And there are three big pain points here. Number 1, financial costs. Attorneys and executors charge fees, and in many states, Those fees are set by law as a percentage of your estate. Number 2, temporal delays. Your assets can literally be frozen in place for 9 to 24 months. Number 3, loss of privacy. Once your will goes into probate, it becomes a public document that literally anyone can search and read. Let's dig into each one of these, one at a time, starting with the money. Here's something that shocks most people. In big states like California, New York, and Florida, probate fees are not based on how much equity you actually have. They are based on the gross value of the asset. Let me give you the exact example from our data. Say you own a home worth $2 million, but you still owe $1.2 million on the mortgage. Logically, you'd think fees should be based on what you actually own, right? The $800,000 in equity? Wrong. The court still calculates probate fees on the full $2 million value, mortgage, or no mortgage. That difference alone can translate into tens of thousands of dollars in fees that could have been completely avoided with a properly funded trust. This is exactly the kind of hidden cost that catches families off guard. Now let's talk about time, because probate isn't just expensive, it's slow. Here's a rough timeline of what your family might go through. At month 0, the death occurs and the will gets filed with the court. Somewhere around month 3 to 6, the court handles asset appraisal and notifies creditors. By month 6 to 12, creditor claims are being resolved. And it's not until month 9 to 24 that the court finally issues an order to actually distribute the assets. Now imagine your family needs money during this time for funeral costs, for daily bills, for a mortgage payment. But the house, the accounts, the investments, they're all frozen, waiting on a judge. That's the real, human cost of probate. It's not just paperwork. It's your family's ability to move forward with their lives. Here's the part almost nobody talks about: privacy. The moment your will enters probate, it becomes a public document. Anyone, and I mean anyone, can walk into a courthouse, or in many places, just search online, and see exactly what you owned and who's inheriting it. Who exactly is looking at this stuff? 3 types of people. Financial predators, who use these public records to identify high-value targets. Litigious individuals, who might see an opportunity to file a lawsuit once they know who inherited what. And marketer scrapers, who harvest the names and contact details of your beneficiaries to sell them or spam them. So it's not just a privacy issue, it's a real exposure risk for your family, right when they are most vulnerable. All right, let's flip to the solution side, starting with the Revocable Living Trust, or RLT. This is really the foundation of smart estate planning in the US. Here's what makes it interesting. With an RLT, one person can actually wear 3 different hats at the same time. You're the grantor, the person who creates the trust and writes its rules. You're also the trustee, the person actually managing the assets day to day. And you're the beneficiary, the person receiving the benefits while you're alive. And because you're the grantor, you keep total control. You can modify it, amend it, or completely revoke it whenever you want. That's exactly why it's called revocable. But here's the real magic. If you become incapacitated, or when you pass away, a person you've already named, your successor trustee, steps in immediately. No court, no waiting, no conservatorship battle. They just take over, exactly the way you planned it. Now, I need you to really pay attention to this slide, because this is the single biggest mistake people make with trusts. Here's the critical rule: a trust, by itself, is just an empty legal shell. Setting one up with a lawyer does absolutely nothing on its own until you actually move your assets into it. This is called funding the trust. What does that actually look like? Your real estate deeds need to be retitled. Your brokerage accounts need to be retitled. Even shares in a business you own need to be retitled. Basically, anything titled under John Doe needs to become John Doe, trustee of the Doe. Revocable trust. And here's the brutal part: if you skip this step, if you forget even one account or one property, that asset is not protected by the trust. it will still default straight into probate court, exactly like it would with just a will. So don't just create the trust, actually fund it. Now let's level up. This section is for anyone getting close to, or already past, the federal and state estate tax exemption thresholds. This is where irrevocable trusts come in. First, the SLAT, Spousal Lifetime Access Trust. This uses your lifetime gift tax exemption, but the clever part is your spouse can still receive distributions from it while you're alive. Second, the ILIT, Irrevocable Life Insurance Trust. This pulls your life insurance death benefit completely out of your taxable estate and gives your family tax-free liquidity to cover any estate costs. And third, DAPTs, Asset Protection Trusts, sometimes set up as foreign trusts. These shield your capital from personal injury lawsuits, malpractice claims, and business liabilities. These are advanced tools, but if your net worth is growing fast, these are exactly the structures serious estate attorneys start recommending. Now here's something important. Even with a great trust, you should never rely on just one document. Smart estate planning is layered, like a safety net with multiple backups. That's where the pour-over will comes in. Here's how it works in 3 simple steps. Step 1. Say an asset accidentally gets left out of your trust. Maybe you forgot to retitle one account. Step 2. Your pour-over will activate as a backstop, catching that stray asset the moment you pass away. Step 3. That asset gets poured into your trust. Now, quick important note, that specific asset does still pass through probate first, since it was outside the trust. But once it's through, it follows your trust's instructions for distribution. So think of the pour-over will as your safety net for whatever accidentally slips through the cracks. Here's a shortcut a lot of people don't know about. Some accounts skip both wills and trusts completely through something called direct beneficiary designations. First, retirement accounts, your 401k or IRA. These require you to name a primary and a contingent beneficiary directly on the account. Just a heads up, naming your trust as the primary beneficiary needs careful evaluation because of the Secure Act's 10-year payout rule, which can create tax complications. Second, bank and brokerage accounts. These can use TOD or POD designations, transfer on death or payable on death. If you haven't set up a trust yet, this is a fast, free way to make sure that specific account skips probate entirely. These aren't a replacement for a full estate plan, but they are a smart, simple layer to add on top. Okay, let's bring this all together into an actual action plan. If you're a high-income family in the US, here's your blueprint. Step 1. Execute a Revocable Living Trust as your core structure. This becomes the primary vehicle for your real estate, taxable brokerage accounts, and any closely held business interests. Step 2, and I cannot stress this enough, fund the trust immediately. Execute the deeds for your real estate and update the ownership records at your financial institutions. Remember, an unfunded trust protects nobody. Step 3, layer in irrevocable structures if your net worth is approaching those exemption thresholds. This shields your appreciating assets from the 40% federal estate tax. And step 4, maintain a biannual audit. Life changes, marriages, births, new properties, new business ventures. Update your successor trustees, your guardianship clauses, and your asset titling every 6 months to a year, so your plan never goes stale. Let's recap everything with 5 key takeaways before we wrap up. 1. A will guarantees probate. It's public. It can cost 3 to 8% of your gross estate, and it can take 9 to 24 months. 2. A properly funded Revocable Living Trust bypasses probate entirely and keeps your family's affairs completely private. 3. An unfunded trust is basically worthless. Retitling your assets is the one step most families accidentally skip. 4. Irrevocable structures like SLATs, ILITs, and DAPTs add real tax mitigation and creditor protection that a revocable trust alone cannot give you. 5. A pour-over will combined with TOD and POD designations closes the remaining gaps. No single tool works completely alone. It's the combination that protects your family. And that's a wrap on trusts versus wills in the US. I really hope this gave you a clear, simple picture of how estate planning actually works, and why relying on just a will can leave your family exposed to costs, delays, and a total loss of privacy. Quick disclaimer before you go. This video is for educational purposes only. From Fintelliq's institutional research. It is not formal legal, tax, or estate planning advice, and estate laws vary a lot from state to state. So before you execute any trust structure, please sit down with a qualified estate planning attorney and a CPA. If this video helped you understand your options better, smash that like button, subscribe to Fintelliq for more deep dives like this one, and drop a comment telling me, are you team will or team trust? I'll see you in the next video.